And while Jackson-Bolanos on the docket today for jury trial in progress. Appearances, please.
Good morning, Your Honor. Ryan Elsey for the people.
Dominic DeGrazia on behalf of the people.
Ryan Brown on behalf of Mr. Jackson-Bolanos.
Good morning, Your Honor. Brenda Cushing from the co-counsel on behalf of Mr. Jackson.
And I open the record, Mr. Jackson-Bolanos is present. Our 14 jurors have returned. Good morning, ladies and gentlemen. Hope you had a good holiday weekend. And we left off with Mr. Jackson-Bolanos on the stand yesterday, or on Wednesday. So, sir, if you could come forward, be sworn by the clerk again. And from the chair.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do swear.
Thank you. Proceed.
Good morning.
Just hold on. State your name again. Just.
Michael Manuel Jackson-Bolanos, B-O-L-A-N-O-S.
Thank you.
Good morning, Mr. Jackson-Bolanos. When we left off on Wednesday, we had just previously heard two separate jail calls between you and Tier.
Yes.
And in one of those calls, you mentioned, I guess, there was some conversation about a washing of the jacket.
Yes.
Jacket.
I wasn't aware that she had washed it.
Okay. When did you become aware that she had washed it?
That phone call.
That phone call? Has she ever told you prior to that phone call that she washed the jacket?
No.
Did you tell her to wash the jacket?
No.
Does she wear that jacket?
She does.
Okay. And how often does she wash your clothes?
Whenever I just put clothes in a basket.
Okay. And on this particular, I guess, occasion on October 21st, did you put the jacket into the basket?
Yeah, I did.
Okay. And when you put it into the basket, did you notice any blood on the jacket?
No.
Now, you were speaking with Tierra and you were, I guess, saying no, no, no on the second call after the first call. Why were you saying that?
The call was being recorded and monitored, and I knew the prosecutor was looking for anything, so I didn't want to be perceived as guilty by washing a coat that I did not wash or intend to wash, like to look as if I was hiding anything.
You also made some statements about, I guess, you would exit out this.
I
What
was
do you
just
mean by that?
I was just referring to, like, it was Michael Jackson, Jackson 5, like, all that's dead. Like, I'm not about to go to jail for something I didn't do. So I said I was going to exit out this jail system.
Okay. And what did you mean by that when you said you would exit out the jail system?
Just like I would leave the jail system.
And what way would you leave the jail system?
I mean, the legal way.
The legal way? Now, I want to go to People's Exhibit 1. And I want to ask you some questions about, I guess, which route you would have taken. place this backpack?
When I found it in the car right about here, I noticed there was a walkway right here. I put it in the bushes at the corner. That was when I noticed the cars in the parking lot that I said that I would just come back to check out those cars. And then I placed it in there after searching through it, like, you feel me? And then I walked that way and went to this place right here.
Okay, and what did you do at that place? And what's the name of that place if you
Ducharme place.
Ducharme place, okay. And what did you do when you went to the Ducharme place?
That was where I had found that Challenger scat pack.
Okay. And did you do anything with that Challenger stat pack?
I took pictures of it.
Take pictures of that. Okay. And on your way back to this particular area, could you just basically just show us which route you took on the way back to, I guess, when you actually retrieved the bag?
When I retrieved the bag, or
Yeah.
to like.
Yeah, before you retrieved the bag. So
Well,
you're coming back into this particular
It's
area.
not on the screen right here, but I was walking past the Bob Maxey Ford place and cut through, and I crossed over and went through this entrance right here.
And then after you cut through the entrance, where did you go?
I checked out a few of these cars right here, then walked right here, checked out these cars, then went into this parking lot, checked out these cars, then came out, seen security, I ducked behind a car over here, he made his way down, he parked at the corner, I checked a few of these cars, and then when he was pulling off again, I didn't know if he was coming back around, I took this walkway. I'm out to come retrieve the bag from right here.
Okay, and when you took this walkway that you just showed us, what, if anything, did you see?
That was when I saw a dark figure upon like right here on the ground.
You were there, or the dark figure was there?
Well, when I was walking, that's where the dark figure was, about right here. I was walking about like right here.
Okay. And you stated that at first, could you tell what this dark figure was?
Not at first, until I got like close enough to see that it was a person I hadn't fully come into contact with.
Okay. And at some point in time, did you realize it was a person?
Objection. Your Honor, we've already gone over all this. Now he wants to go over this again. These have all been asked and answered.
They have been asked to answer.
Now, you stated, I guess, on Wednesday, that you, when I asked you, could you tell the race of the person? Remember that?
Yeah, I stated that I couldn't. I didn't know whether she was like Italian, British, or German, or Swedish or whatever.
Okay. Did you know whether or not she was black or white?
Ethnic? Yeah, white.
So we'll fast forward into the interview that you had with Sergeant Ford. Why were you repeatedly saying, I didn't see somebody laying on the ground?
When he was asking me the questions, or basically telling me that I went in somebody's house that I didn't go into, I was picturing what I had saw that night. A woman was outside on the ground.
Okay. So just to be clear, when you having your exchange with Sergeant Ford, you were picturing her laying down on the ground?
Yes.
Okay. Is that why you kept repeatedly saying, I didn't see anybody laying on the ground?
Yes. And I was also denying the fact that I did not kill her.
Now, we also heard a telephone conversation between, I guess, you and your attorney. Well, we heard partially. You remember that particular conversation?
Yes, the call after the preliminary.
Okay. And you would recognize that call if you heard it again, correct?
Yes.
Okay. I'm going to play defense proposed exhibit 11, which is the entirety of the phone call between Mr. Jackson-Bolanos.
Judge, I'm going to object for the
Please, brother. Objection overruled. The door was opened when you played a portion of it, so they get to play the whole phone.
Now, Mr. Jackson-Bolanos, this phone call was this after a preliminary examination?
Yes, I stated that.
And was this preliminary examination held in a different court?
In 36?
36 district court? Okay. And was there a different judge that presided over that exam than that's presiding over this trial as of right now?
Yes.
Thank you. And I would like to publish defense exhibit 11.
This is a call from and paid for by.
Wait. Wait, this is defense's what?
Exhibit 11.
Defense 11 is admitted, you may publish.
And there is a lot of dead time, like 5 minutes of dead time, so I'm going to start at 5:34.
5:26.
At first, when I first got there to leave you, he said, but after the question you asked, he said, man, you really target his armor. Like, you really put kinks into his armor. And he said, normally when I cover these type of cases and the case is bound over, I don't think nothing much of it, man. He's like, man, your guy gonna get off.
Man, I was so broken. I ain't do this shit. But
I'm
just saying, once again, I was also parking I also parked the permanent food. She's gonna come see me tomorrow. I was wondering, will you come in to see me tomorrow? But you just stated that you got a case tomorrow, so.
My case is at 1:30, so I can come see you before then. I mean, I got some cases in the morning, so I'll have some time.
She wants to meet up with you. You feel me? She's gonna go buy a 5 terabyte or 10 terabyte hard drive, and she wants to meet up with you.
Okay, if she brings it down there, because I have two different hard drives. I got a hard drive that needs to be plugged in that has a little bit more stuff on there than the hard drive that I brought today, because the one that they gave me, you got to plug it into the wall and it needs a special encryption key and everything. So.
Yeah.
Mm-hmm.
But yeah, I just wanted to go over some more stuff real quick, you feel me? Just like little questions I may have since we leaving into jury factor, you feel me? And then like from my knowledge of the jury, like bro, they could, you feel me? And then now I've been amended, meaning I got a new charge, right?
Yeah, you got a new charge, which is first-degree murder. But in my opinion, they're not going to be able to prove that. Like I said, it would have been easier for them to try to prove that you broke in there to rob her and then you killed her. But now they got to prove basically that, you know, you went in there with the intention to murder her. They're not going to be able to prove that. I was reading some of the comments under the video, man. A lot of people was like, it don't add up. Like, it does not add up. You innocent, man. You got a lot of people in the outside, in the public, saying that it don't add up.
Man, shit, realistically it don't, and logically it don't, bro. Because logically I ain't got shit to do with nothing. Realistically, I don't got shit to do with shit. So it's like, you feel me? People, when I go and explain the reason why I say what I said in interrogation, because you feel me, that makes perfect sense.
Yeah, I get it. I mean, I 100% get it. I mean, I know exactly what you're coming from.
And then, like I was saying, bro, we do the cross exams, man, these guys, and like she was saying next to me, man, these guys do not know how to answer yes or fucking no. They like to give a descriptive, and that's where we got to cut it off. I didn't ask none of that. It's yes or no. Cause you see they fumbling with their words. Yeah. Then they look at the prosecutor, and then the judge chimes in when he feels them trembling. The judge was chiming in like, "Are you've been here 13 years, and you like you're not that like, but you know that like, bro, what the fuck is he on? You feel me? That shit was weird, but it's like, bro, and then he falling asleep up there. You even caught it this time. You feel me?
Yeah.
Falling asleep, but it's like, man, I wanted him recused from the beginning. Just off of
that wasn't going to happen. I can tell you right now, you can't, that wasn't going to happen from the get-go. But we did get our theory across. Like, everybody was watching it. Yeah.
No, I said, no, you did amazing. You did a tremendous job, for sure.
Yeah, so the theory has been established, and everybody who heard the theory was like, yeah, that makes sense. The prosecutor's theory doesn't make sense at all. It was a victim of circumstance. Circumstances, you were in the area. You can explain why there's blood on there. It's very reasonable. And like even the judge said, you know, so he finds it very peculiar. This is his word. I find it very peculiar that there's not more blood on the front of you because the crime scene had a tremendous amount of blood here. I mean,
and then y'all got all the clothing I had on that night, some shoes, pants, coat. Like, come on, bro, what the fuck?
Yes.
And even if you can't wash that shit off because it's still gonna be there.
And that's what the
judge only shit that don't disappear. The only shit that don't disappear.
That's exactly what the judge said when we came up there. He said when he asked him, he's like, man, I find it peculiar that he was talking to us. He's like, that there was no blood other than those two spots on his sleeve. And the prosecutor was like, oh, he may have washed it. And the judge was like, no, that wouldn't explain, you would have some traces of blood other than, just on the arm. You would have it on the front. Just like I said, you would have it on the front, you would have it on the shoes, the other items that wasn't there. So, and then he tried to say, oh, it might be another item, it's a small blood on the back. I'm like, yeah, that's just, if he would have had blood on his hand and picked up the backpack, and the judge kind of shook his head, and then the prosecutor would say, now, the prosecutor's feeling, like I told you before, I can't guarantee it, but I have a feeling that these people will not really stop. Like, the prosecutor, I think he's having second guessing. Like I told you when I first talked to him about our particular theory of what happened, and he was like, why didn't you say that at first? He was like, why didn't you say that at first? And then he was like, he said, we thought that might be an issue too, where he found the body, and then, try to run her pockets.
Yeah, like, come on, bro, how if this person had everything still there?
Absolutely, absolutely. There was nothing that was mistaken. There was nothing that was taken. No evidence that anything was taken, even though there was evidence that things were in plain view. The credit card was right on the table. You saw the credit card. The laptop was right there. The phone was right there. You had whoever it was had an opportunity to check it. This was not a theft involved. This was something else. It had nothing to do with no theft. Whoever went there did not come to steal something from her. Somebody went there to steal her, and they had ample time. They had a lot longer than 60 seconds to tussle with her from room to room, to beat her up. She got bruises all on her body from head to feet. And then be able to get out of there. It was a huge shit that there's like the fact that you were emotionally in there at 4:20, and then you were seen and losing a half a mile. Right to the court. It was like, yeah, he was then seen a half a mile away on another surveillance just 3 minutes later. So everybody's down, and I talked to the guy personally. He called me, he was like, man, you did an excellent job. He was like, man, you put the key to their arm, and normally when the case is bound over, I don't think nothing of it, man, but the questions you asked, he had me thinking like, about whether or not it was the right time or the right date when the officer was testifying. They don't know, they socially independently verified whether or not the video came from
Brian, yeah. I hated that, bro. The prosecutor was furious, so every witness after that, he kept asking your questions to him before you could ask your shit. I'm like, he was furious. He was furious.
They can't substantiate that. I mean, first of all, they can't substantiate the phone, they can't substantiate you, and then more importantly, anything. Boy, the timeline just does not add up. I mean, it don't add up.
60 seconds, it's impossible. It's realistically impossible. I don't even think you could do it in a movie. You feel me?
No, you can't. You can't. And then to make it, around the corner, a quarter of a mile away, and you're walking, you're not running nowhere.
And I'm walking past witnesses, I'm walking past everybody.
Yeah,
I'm not hiding my face, I'm not ducking down, I'm not doing none of that weird shit.
None of that.
Anything on me would have been like, dang, what the hell? Would have pointed instantly. Like, man, look at that guy.
None of that. You're not wiping your face. None of that stuff. You're not wiping none of that stuff. I mean, it's obvious. If it makes it that far, with, I don't know, the prosecutor, he would say, hey, you don't have to be not guilty and stuff like that. And he said something, you don't believe, I think he's being forced, but he said something himself was a fightable case. He wouldn't even look at me when I was looking at him like, this particular theory. So he may be telling his supervisor, and I can't say he will or not, but he may say he may got the wrong person. He may feel that way too because the judge was like that. I was like, Judge, I don't feel it's okay.
They're being forced, and then not only that, look at the type of ethnic background of the victims, you feel me? And the type of political or whatever media power or whatever power they have, they're forcing these, they're rushing everything, they're forcing these people to do something. And then the lady, the supervisor prosecutor, the KW lady, you feel me? She maybe, you feel me? Oh, they rushing me and bothering me about it, like how they were bothering the media and everybody about it. Because what's going on? What's taking so long? Come on, we need somebody. So now they just thinking the easiest arguments, they believe whatever they need.
It's going to cost them. That in the long run, their hastiness in this case on charging you and making a press conference, putting your picture out, all that stuff, that's going to cost them in the long run. That's going to come back to bite us.
Yeah. So do you believe, that's what I want to talk to you guys both tomorrow, do you believe speedy FT or not?
I mean, we're not going to waive your right to a speedy trial. We're going to have it, it's going to be in a particular fashion. I
ain't trying to sit in here.
We're not going to waive your right. No, we're close to that. We're not going to waive your right to a speedy trial. We're going to come forward, at a reasonable time. So when next Tuesday, we're probably going to set the project. It's probably going to be sometime realistically, maybe this summer. It's a January, because we need to record about February, so it'll probably be around, maybe May, June-ish. by the time you go to trial. Give or take. Don't quote me on it. It all depends on the court schedule and everything also. But after around June is usually going to trial.
Damn, that's still far. June-ish?
Yeah, that
I'm thinking this was speedy is like right then and there. Like, all right, after the 30th of this month, we're looking at March.
You get too soon because, for one, we're not going to have the preliminary exam transcript. That's going to be a while because the exam was so long, so we're going to take a little bit for them to get that exam transcript because we definitely need that before we go to trial because we might have to impeach some people if they try to say something differently than when they testify to the exam. We'll be like, hey, bam, you said good back on the exam on January 23rd. Now you said something different.
Right, like people was doing and fumbling and rewording and trying to go around. And that's another thing too, man, no going around the questions. No trying to reword, rephrase, and re-cameo statement and say it's a strictly yes or no. And we were saying that together, whispered each other, like, man, why they can't just answer yes or no? Why they keep trying to, oh, well, I know this from doing this and this experience of doing it. Bro, yes or fucking no. Like, every time they do that with you, bro, because they really know they on bullshit. So they try to do that weird shit instead of just being real and saying yes or no. You feel me?
Yeah. I mean, we on that, yeah, definitely. And yeah. We got to talk to these from each individual because when it boils down to our theory, basically has been established by. Some of the people didn't really matter. Some of the people, they don't really have too much to do with it. The more important individuals are going to be the guy who basically did the phone matter. We're going to have our own phone guy. We talk to him. So that is the stuff he testifying to is going to be discredited. Basically, there's no way from his phone mapping that they can pinpoint where you are. All they can tell you is in a general area. Just like they had the longitude and latitude for her phone, with the company of Marco was testifying that the latitude moved, so she basically couldn't tell if the phone was moved the location-wise during this time period. They could have got the exact same location information from your phone. The FBI didn't still to himself. FBI guy said that if I had the phone and we would have put it in this particular system using our software, we would have been able to tell you, specifically where he was at as far as latitude and latitude. They didn't do that stuff because they don't want it to be done. But we're going to have our guys with that information. They don't want that information to be out because that discredits their whole theory of, it would say, you're in the area. They know, I believe they really do now. They just want to have the people assume that you was in the area, so you must have done it. And that's not going to be enough to prove you beyond a reasonable doubt. It's not going to be enough.
So everything that was on the record here, nothing, all the shit that was admitted, all the shit that was admitted into, you feel me, MRE 90211, everything that wasn't objected to, that's all supposed to be bonded over to, right? That's all the evidence that they're using, that's everything that they're using.
At trial, they're gonna have to reestablish it again. You carry it over from preliminary examination. That's something I said for preliminary examination purposes only. Preliminary examination is different than a trial. So the preliminary examination, like the lab reports, the medical examiner, they let certain things come in without the person testifying to at an exam. At a trial, the medical examiner has to come and testify. The individuals who did those lab reports will actually have to come in and testify. So it's different rules that apply at an exam. An exam is a lot less lenient. More lenient.
More so in the thing, if this was a poker hand, if this was poker, who's looking good?
Well, yes. And as far as establishing, planting seeds and establishing our theory, you're looking good. I don't believe that they can't prove beyond a reasonable doubt that you did it. They have no evidence. Even the judge had to say it's very plausible, it's very possible that, you know, being a quote-unquote thief you are, came across the body.
He still had to defame a nigga. Still had to.
I mean, like the cameras on.
Why would you say that I had to check her pocket? Like, bro, I'm not no dirty nigga, bro. I'm not doing no weird shit like that.
No, not at all. But at the end of the day, he even had to admit himself that it's very possible of our theory that she died earlier, got up, stumbled outside, and because you, just like the other witness, came across her body and touched her.
Yeah.
For whatever reason he said you might have touched her, he said that's very possible. And had the cameras not been there in his face, and all the cameras not been there in his face, he would have dismissed that case. Just for him saying that is a possibility. Because normally if he would have felt the way, he would have been like, oh yeah, I think he did it, I think the client did it. But he was like, he said that multiple times, that it's a possibility that you came across the body, and that would explain the little bit of blood, because to him, it was very peculiar that all that blood in that house, in that apartment, you only had 2 little specks on the back of your sleeve? That don't make sense.
Don't let them fabricate nothing, man, and then get to putting more specs everywhere else now.
No, it can't be done now.
After they already ran everything, they say, oh, it's another one, we checked again, now we got this. Like, no, hell no.
No, it's too late now. It's way too late for that now. Once we establish that on the record, once in front of, if we make it to the jury, we're going to question on why would they run this backpack, because they got pictures of the backpack at first. Why would you run this backpack 2 months later after you ran everything up? You submitted everything back in October, and then that's why we've been bringing this stuff. That's why we didn't bring it up. Now, we didn't bring that stuff up at all. You know what I'm saying? So it don't pass the smell test. Like, you had all this evidence, you ran all this DNA, everything. You ran so much DNA in the month of October and November, and then at the end of December, almost January, you're going to submit this backpack, and we're going to have these pictures of where they extracted his blood from. It don't even add up. If you look at it hypothetically, even if they say, okay, the jury may feel like, okay, yeah, that's her blood on there, it's explainable because them themselves said you didn't have a backpack on, and then you had a backpack on, so you had to grab his backpack from somewhere, and he's not suggesting that you got it from her. So wherever you had your backpack, you had to touch it, you had to put it on your back, you know, and if you touched her and had blood on your hands, then it would have been a microscopic.
They also mentioned, notice I didn't have the white bag anymore either.
Yes.
All of a sudden I got a door bag, so what happened to the white bag? How you know that person was this person in here with that? You feel me?
How do we know that's you?
Right, and then y'all don't even know. And then they kept dodging that question, so that's why we confessed and bring the GF. You feel me? We bring up that GF.
You said bring up the what?
The GF, we bring up that, you feel me?
Oh, yeah.
And that's going to show that they did an illegal task to identify a POI, you feel me?
Yes. And that issue is going to be litigated way before trial. We're going to litigate that issue with a motion, and the judge is going to determine whether or not he's going to lie. Whoever our judge is going to be, I don't know. It might be Judge, I don't know who the judge is going to be. Might be the chief judge, Judge Knapp. He's pretty. I've had some good rulings from him in the past. So he might. We don't know who the judge is going to be, but we're definitely looking at this. A week from today.
Okay.
So we're arrangement of the information. Basically, going to arrange you in circuit court. Nothing's going to be happening. Probably get some dates. Order the transcript. You'll order the transcript next week. Give a motion cutoff day that all the motions got to be due by a certain time, and I would suspect that we will get trial dates next week too. We'll set the trial dates sometime in the near future.
Okay. Damn. All right.
Yeah.
I just hate sitting in here, bro.
Yeah, I understand. Yeah, I mean, it's not in vain. I mean, like I said, it might be a blessing in the
lost my granddad, that shit, I didn't even know that shit. Now I'm emotionally damaged, not even more.
Yeah, I feel bad about that. Did you get an opportunity to call your dad?
No, I ain't get no answer or nothing. But, you feel me? I don't know, man. Yeah, that's a lot, man. It's a lot. But all this plays into whatever happens after this, you feel me?
Yeah, absolutely. Just don't worry too much. It went pretty good. I mean, I'm not surprised. I would like to have had done the right thing and dismissed the case. But given the publicity, I mean, we knew from the on-side that wasn't going to happen. But we had...
The words that you said was awful shocking too, like, dang. But why, if you felt this way in your heart, after I told you we had to stare down for 3 minutes, like looking into each other, and I'm like telling them with my eyes, like, bro, be honest, be realistic with yourself. With my eyes, I'm telling them, like, you really, and that's why he felt that type of way, like, damn, and then with your story too to back it up, so he like, damn, why, if you really felt that in your heart, bro, you should have did the right thing, but like you said, the media and all that shit, so you feel me?
Yeah, the media and it's a possibility. I can tell you right now, the prosecutor would have appealed it. So if the judge would have dismissed it, then the prosecutor can appeal it up to the circuit court, and if the circuit court, they could reinstate the charges. They can say, oh, the judge,
right back, he got me.
And they can come and it'll start back over. So I think that might be the reason why. I can't get in the judge's head. I think it's partially the media and partially in his heart. I think he was like, this guy won't get off. You know what I'm saying? And it needs to be a not guilty. That's the only way they can recharge him is if it's not guilty. That's double jeopardy. So hopefully it won't make it that far. But if it goes in front of a jury and the jury comes back not guilty, bam, nothing they can do. You can sue them. But right now, if he was dismissed the case, you can try to sue them, and then they can reinitiate the charges. And then, okay, you don't have a lawsuit right now because you're still charged with murder because they reinstated the charges based upon they show the judge abused his discretion. But he was very clear, and I'm going to follow most of the cross too. Most of the cross goes and saying the judge abused their discretion when he bonded over. But he was very clear, and you already know, to state that it's a possibility that you didn't do it. Like he said to himself, there's a possibility that you didn't do it. So the fact that you still did come back and do it, not motion the process. You felt that way, it's a possibility. Therefore, the prosecution, in my opinion, didn't meet their burden to show probable cause. It's basically still a theory. Like, it could be yes, it could be no, but they don't have anything that could substantiate it was you other than a theory that doesn't even add up.
For this call.
Yeah, so if you peel back the layers and you look at it, as a logical individual, you'll feel the same way that you're innocent.
Yeah. Yeah, so, man, I will see her tomorrow. She come up here tomorrow. And then, if possible, can I see you too? Can you both come?
Yeah, I can come tomorrow. I'm not sure what time she's coming. I can come after when I get out of. I'll come around maybe like 10 o'clock, 11 o'clock. I should be there about 10:30, so I'll come up there.
Okay. Yeah, man, because we'll talk more in depth tomorrow,
Yeah.
Man, like I said, man, I appreciate it. Just believing in the Most High, man. That's it. Yes.
Absolutely.
All right, man. Appreciate it, B. Thank you so much, Attorney Brown.
Oh, yeah. I'll see you tomorrow.
All right.
All right.
Now, Mr. Jackson-Bolanos, we just heard the entirety of this conversation. What did you mean by it when you said you're not a weird person, basically?
The judge was basically stating that.
Objection. Calls for hearsay.
No, he responds to why he said a particular thing. We're not saying it for the truth of the matter asserted of what the judge
Well, he
said.
doesn't have to say what the judge said. He can just say why he said that.
Okay.
Comments was made that the thief I am, I probably ran her pockets. That was untrue. I'm not that individual to take anything from someone dead.
Okay. Were you denying touching her during this conversation?
I was denying just violating her in any way, touching her inappropriately, or taking anything from her.
Okay. And just to be clear, did you take anything from her?
No.
conversation about haunted houses. Did you ever check on your phone about for haunted houses?
Yes.
Okay. Do you know when?
October, early October.
Did you ever end up going to a haunted house in October?
I went to a couple of them.
Okay. There was also some conversation about a black light. Do you remember any searches about a black light?
Sort of, kind of when it was brought up, but that was like in reference to when I was at a haunted house party. I was noticing a lot of lint on my clothing, and I looked to see what else it sees.
Okay. Did you ever search Southwest careers? On your
Yes.
phone? Okay, and why were you doing that?
I had just got back off the road like the month before October from driving trucks, and I wanted to take up flight attendant or airport dealings.
Okay. Did you also search what type of airlines or what airlines are basically felon friendly as far as hiring?
Yeah, as far as I knew, Southwest and Delta were, but I had filed on Delta. Delta tried to scam me. I had went to the wrong page.
Okay. Now, why were you searching if airlines were higher felon? Why would you search them?
Because I'm a felon.
Okay. Have you been convicted of receiving and concealing stolen property?
Yes, motor vehicles.
Okay. And what is that in relationship to those particular charges?
Basically going out scouting cars and eventually stealing them.
Okay. And have you been convicted twice of that?
Yes, I have.
Now, you stated that you made a comment saying you wouldn't take anything from a dead person, correct?
That's correct.
From their person, correct?
That's correct.
Okay. Would you take anything from a live person? Like, would you rob a live person?
No.
So, in your mind, what's the difference from stealing from a person's actual body than stealing from a person's car?
To me, the difference would be scaring somebody, hurting somebody, to take from them. If I take from a car, there's nobody. I'm not hurting anybody. I'm not bringing any ill will towards anyone.
Okay. Do you think that if you steal somebody's property from their car, it could possibly bring them ill will?
Yeah, I could see that.
Have you been convicted of robbing somebody?
No, but I had a situation in juvenile.
Why wouldn't you go into somebody's house as far as committing some type of home?
First and foremost, I don't know what's behind waiting for me if I do go in anybody's house. I never went in anybody's house before, even as a kid. I don't do that. That's never been my thing. I'm not into B&Es or home invasions.
Okay. What do you mean by you don't know what's waiting behind you, behind the door for you?
Everybody and their mama and son and kids got guns. I'm not putting my life on the line like that.
Did you have a gun when went out?
No, I didn't. I'm a felon. I can't have none of that.
Okay. Now, was when you went out to, I guess, scout cars on this particular night, was this a common thing that you did around this particular time, or?
It was just, I had, previous to dropping Miss White off to work a couple of days prior, I had synced that Charlie, and I wanted to find it. When I synced it, turn in one of these locations.
Okay, and when you say Charlie, are you referring to?
That scat pack that I took a picture of.
Okay. Since this particular night, have you went out scouting for cars or hitting door handles?
No.
And why haven't you?
The night was shocking, like, synced a dead woman. I'm done doing all of that, I'm straight.
Had you ever came across a dead person while you was out hitting door handles?
No.
How did you feel when you got back home about that?
Just weirded out to the fact that I touched her.
Okay. Did you mention anything about it to Tierra White?
No.
Okay. And why not?
It had nothing to do with me, so it wasn't worth telling anybody.
Thank you, Mr. Jackson-Bolanos. No further questions.
Cross?
It was time for sure.
Yes.
Yeah, Judge.
Well, actually, I guess the people are proposing.
Yes, Judge. Last Wednesday we were in court. The defense introduced, I believe it was Defense Exhibit 10, one of the phone calls between the defendant and his girlfriend. In the course of this phone call, the defendant said words to the effect of, I don't do weird shit to women, or I don't hurt women. I can't remember verbatim exactly what was said. But both in that call and today, he has testified that he doesn't rob people, he doesn't hurt people. Now, that is character evidence that the defendant has introduced. The phone call that was made to his girlfriend, that was specifically redacted to not include that character evidence. The defense insisted that that full, complete exhibit be admitted. The jury has now heard that exhibit. The evidence has been introduced by the defendant, and pursuant to Rule 405A, cross-examination on this point is permitted. I'm also referring to the case, it's a Michigan Supreme Court case, People v. Lukity, that's Lukity, at 460 Mich 484, when the defendant introduces evidence of his character for a pertinent character trait, in this case, the defendant's on trial for killing a woman, we should be permitted to cross-examine him on those topics. And so I would propose to use specific instances of conduct, and I can get into that if the court wants, but specific instances of prior conduct by the defendant, and he should be cross-examined on these points.
And first of all, Mr. Jackson-Bolanos never stated that he doesn't hurt women. He said he doesn't do weird stuff to women, which he stated in his interview, which they played to the jury when he said in front of Sergeant Ford and Patrick Lane that I don't do any weird stuff. They've already heard this. It's nothing more than a consistent statement. So it's nothing different than when he previously said they opened that, they introduced it, they didn't redact that particular statement from his interview. But so none of them, they want to cherry pick. It's similar and exact same statement that he said to his girlfriend on the phone call. That is not character. He said, I don't do weird shit. He didn't say I didn't hurt women. I don't attack women. I don't do weird stuff, which is exactly what he said on the other phone call he said to me in response to whether or not he took something from the body of Samantha Woll when he came across. He said, I don't do that weird stuff. He's been consistently saying, I don't do weird stuff on multiple recordings that they played. 2 out of the 3 recordings that they played, he said a very similar statement. So then the fact that we introduced something that he says the exact same thing, which doesn't even go to his character, they want to try to say that this is character evidence that allows them to cross-examine him on things unrelated to the statement that he just stated. He was very specific on I don't do weird stuff, and every time it was in relation to whether or not he came across that body and did something to her as far as taking or removing anything from her body. That phone call with his girlfriend was after the insinuation by Judge King, when Judge King insinuated that being the thief he is, he probably came across the body, touched the body, and tried to run her pockets. And he categorically denied that with the conversation that me and him had. The prosecution tried to insinuate that he meant, oh, I didn't touch the body at all. They tried to mislead the jury by, we had a whole motion hearing on this, getting privileged conversation in that they did not redact on that. So the jury heard him say, I don't do weird stuff. And he was implying to what he's explicitly stating, that he does not take things off of a dead body. Has nothing to do with character. And I asked him, and he was responding to whether or not he's been convicted. We was talking about his convictions, not whether or not he has the propensity to rob somebody, whether or not he's ever robbed somebody. Nobody, that question was not asked. It was about his criminal history. That character trait was never asked of him, elicited from him, nor did he ever respond to it. He was responding to his convictions.
Well, I remember what was said today, but I don't remember the conversation with the girlfriend, exactly what was said. Do you know the time in that exhibit when it was said?
Yes.
And
I just want to know the specific words that were said in
said
example.
specifically the same
Well-
thing he said in the interview. Okay.
I wanna know.
Just stay warm, man. Just stay warm. Like I said, bro, no matter what happens to you, I would not lie to you, bro. I did not do this shit, bro. I don't do no weird shit to women. I don't hurt kids. I don't hurt women. I don't do no weird shit, bro.
Okay. He went on beyond weird shit. He said, I don't hurt women.
I mean, he said the same thing during his interview with Detective with Sergeant Ford. He said the exact same thing. I don't hurt women. I don't do weird stuff. He said the exact same thing that they played for the jury during his interview. He was saying the exact same thing, nothing different. So they want to introduce something, and then he's saying the exact same thing that they introduced, and they want to cherry pick that and say that's character evidence.
He never said, I don't hurt women in the interview with
Ford?
Ford.
He did.
He did?
He did, Judge. Oh, he did.
I remember him saying, I don't rob, and I don't
Oh, no,
hit
yes.
a lick, and I never dropped a body.
Oh, he did.
But Judge, what's pertinent here is that the defendant is introducing this evidence. We never attempted to argue that he is a character for hurting women. The defense is introducing that, and that's why he's opened the door to this. So whether he said it in a prior interview, we never argued that he's the type of person who hurts women. The defendant is the one testifying that he's not the type of person who would do this because he doesn't hurt women, and that's a key distinction here.
I'm not committing no crimes, I'm not hurting nobody, I'm not doing nothing, I'm not stealing nothing. That's just one time he said it. He says it multiple times throughout this interview, Judge. 10159, that's one time he says it. He says it multiple times, Judge. And as a matter of fact, they questioned multiple people who took this stand. They crossed people on this stand and said, do you recall Mr. Bolanos saying, I don't hurt anybody? Did you not think that was odd when he was saying that? These were questions they asked witnesses who they cross-examined. Lane, Ford, they asked these specific questions. Didn't you think it was odd when he said, I don't hurt nobody? Didn't you think that? Those
Okay.
are their questions.
So what about the people's argument that they weren't going to ask any character evidence based on that, but now you've introduced these statements.
Well, Judge, these statements were already introduced via the initial interrogation video, and technically, on the rule of completeness, what we were trying to do was just show the jury that we're not hiding anything in these phone calls. They're trying to fragment the phone calls and enter them. The jury themselves, as we know, had a question as to why these are fragmented phone calls. They asked that question. All we're attempting to do is say, hey, look, we've got nothing to hide from our side. We will show you the entirety of the phone call. And the rule of completeness allows us to do that. That's all we're doing.
Right. And then he's trying to insinuate that the reason why they edited this call was to take out this particular character evidence, which was a 5-second blip out of a 10-minute call. So that's not the reason why they shortened. They wanted to get what they wanted out this particular call to kind of mislead the jury, as Mr. Jackson-Bolanos had a particular state of mind as far as getting upset about the washing of clothes, where the nature of this conversation had a lot more information and evidence in it, I believe, that the prosecutor did not want the jury to hear. So that 5-second blip out of it where he says, I don't do weird stuff or anything, it's the same thing he says. It's nothing new that was being introduced to the jury that they did not hear from evidence that they submitted, from testimony that they elicited from individuals on the phone. And even in their opening statement, they were saying, oh, Mr. Jackson-Bolanos was saying things about not robbing people. He kept saying not robbing people when he was brought into the interrogation, even though nobody asked him about it. So they trying to mislead the jury, trying to act like Mr. Jackson-Bolanos is making affirmative statements about he doesn't rob people. He doesn't rob people. But then they're trying to insinuate that, oh, he must have had a guilty conscience because nobody asked him about robbing people when he first got into the interrogation room. They were talking about glasses. Nobody even mentioned the word robbery. He introduced this word robbery in an attempt to, I guess, clear his conscience, or the fact that he had a quote-unquote guilty conscience about something, and that's what was on his mind. And just the fact that he's consistently saying the same thing he said to Sergeant Ford, to Sergeant Lang, does not mean that he is introducing any new character evidence that would open the door to cross-examination.
And I found it several more times. I'm highlighting it if the court would like me to give them the timestamps for that too.
Yeah, he repeatedly said it.
He repeatedly said it.
I know there were repeated similar types of content.
Yeah.
Replies.
The relevant point here is they made the decision to play the full call. They did not have to do that. They chose to do that. They chose, when he's on the witness stand, to ask him, are you the type of person who does these things? Are you that type of person? The defendant answered the question that way. They have deliberately inserted this issue into the trial, and so now they can't sit back and say, oh, well, we didn't realize what we were doing when he played the phone call. They've opened the door to it, and I should be allowed to proceed with questioning about specific instances of conduct. You can either deny or affirm that these things happen, but it is an area of cross-examination that I should be permitted to indulge in.
They've already opened the door on his character by insinuating that when he's saying, I didn't rob individuals, by them eliciting that testimony from their witnesses saying, did you find that kind of odd? That he's saying he didn't rob anybody. Nobody ever mentioned anything about robbery. So they're basically insinuating that he has a guilty conscience. He's the type of person who robs individuals, even though he's asserting he doesn't. And like I stated, even in their opening statement, they made reference to Mr. Jackson-Bolanos saying, I don't rob individuals, before even being questioned on that. So they're already insinuating on his character. Then they're showing specific incidences from their own evidence where he's denying robbing people, denying doing weird stuff to people, women, anybody. I don't rob people. I don't do anything like that. He's repeatedly saying that. And then they're doing direct examination on their witnesses and eliciting testimony on how their witnesses felt about when he said that. How did they feel when he said that? Did you ask any questions? Did you ask anything about a robbery? So they're already implying his character through the back way. They're trying to backdoor his character in by making insinuations and then asking their witnesses how they felt about statements that were made.
And, Judge, as far as the prosecution saying that we deliberately and intentionally entered these full calls, we didn't ask them to enter partial portions of any calls. We were never intending on doing any phone calls. They did that, and in order for us to appease the jury, who specifically asked a question in regards to why there were redactions to phone calls, we are appeasing them by saying, hey, listen, we know you just got a portion of the phone call. We will play you it in entirety. Every single one that they played. We have introduced no extra phone calls. I'm sure the court is aware of that. They played 3. Exactly. They played 3. We played 3 in entirety, Judge.
Right.
That's all we're doing. So now he's saying, oh, well, we didn't ask you to play. Sir, you played a portion of it. All we're doing is just showing our full hands to the jury and say, hey, look, that's all we did with that.
Which included character evidence.
I don't think that's character evidence saying that he's talking to his girlfriend and he's saying basically the same thing he said during the interview. He's reassuring to her after accusations were made by multiple pieces of their evidence that he did something to this body, either from the judge who insinuated this, they played this, a portion of it was taken out of context, insinuating that at the very least.
Well, but it went beyond that because he said I don't hurt women.
I mean, he
So
said
it's
that.
not just talking about the body.
Right, but he said that during
His
his interview, they already opened the door and then they already tried to undermine his character by asking their witnesses about how they felt to his statement saying he doesn't rob people, he doesn't do this, or he never did this robbery with the glasses.
Well, what they asked was, had you asked him about any robberies? And he was denying doing any robberies when they hadn't even talked to him about a robbery.
Right, but during open statement, he already insinuated that he volunteered this information about not committing robberies. And therefore, he had to be lying because nobody asked him about any robberies. He volunteered the information that he does not do any robberies. They were talking about glasses. So he said this during his opening statement. He's already planted that seed into the jury's mind, and then he watered that seed during his witnesses when he asked them questions about it. After playing the video and audio of his interrogation of him repeatedly saying, I don't rob individuals. I don't rob individuals. And then they asked questions from their own witnesses about those particular statements that he made, and then he's repeatedly saying, I don't do anything to women, I don't hurt women, he's repeatedly saying that. So this is nothing inconsistent or nothing new that the jury did not hear. This is not like we introduced something, a new statement that the jury already did not hear ad nauseum from their own witnesses and their own exhibits. They've heard this multiple times.
But that was in a different context where they hadn't even talked about robbery yet. They just talked about some cars and some sunglasses.
When they brought me in,
Hold on.
This was repeatedly through the interview. This was at the beginning, middle, and the end when he repeatedly stated he does it. Even after when they said that you went into the house. He's like, I don't go into houses. I don't do that type of stuff. I don't go into people's houses. I don't. And then the detective's like, what's the difference between going to somebody's house and going to somebody's car? He's like, there's a big difference. And the detective's like, oh, there's no difference. And my client was like, there's a big difference. So he's repeatedly during this interview asserting that he does not rob people. He does not go into people's houses all through it. And then the detective started to say, oh, you had to go in there. We got you in there. Like, no, I don't do that. Or you had to touch him. Like, no, I don't do anything to women. It was an obvious insinuation that the detective was making that he hurt this Samantha Woll. And he was denying, saying, I do not do anything to women. I don't hurt women. He repeatedly said this from the beginning of his interview, during the middle, towards the end. He was very consistent. He never wavered on that point at all. So for them to introduce that and then act like, oh, it's okay, whatever, it doesn't matter that he said that during our evidence or exhibit, with the fact that he said a 5-second blip to his girlfriend, and therefore they're allowed to now just bring up accusations, not even charge conduct, not even convictions. They just want to bring up accusations that somebody made years ago about him and then put that in front of the jury to try to prejudice them and say, oh, somebody said back when you was in middle school that you took your pencil without asking. Or you did this years ago. Unsubstantiated. We don't have the person here to testify to these acts. We don't have the person who can say, like, okay, Mr. Jackson-Bolanos get me wrong, he did A, B, and C. They're unsubstantiated, they're uncharged, I don't know when they came from, and their prejudicial value highly outweighs any probative value in relation to him making a consistent statement that he did prior to that phone call. The very evidence that they entered against my phone call, he said he doesn't do weird stuff. That was in, so I guess if we played that also, then I guess that's more grounds from, in their mind, that there's character evidence that should be entered, because they played this particular call where he's saying, I don't do any weird stuff.
I've heard enough. Mr. DeGrazia, your response to the fact that you already introduced these statements, similar statements throughout in the interrogation.
The purpose for introducing those statements was not to make the argument, that he has a bad character, or that because he's committed crimes in the past that he committed this particular crime. Nobody was asked any questions about any prior instances of bad conduct on behalf of the defendant. When the defense put forth their evidence, they introduced this character argument that he is not the type of person who would do that sort of thing. So just because we introduced a statement where he denied hurting any women, that does not mean that we opened up the door to character evidence on the defendant. Obviously we didn't, and that's why we redacted copies of the jail calls. That's why we redacted certain forms of information that were in the video recorded statements, because we deliberately did not want to introduce character evidence unnecessarily. But now the situation has changed because they decided that they wanted to introduce character evidence. So the idea that somehow, because we had played that video recorded statement, that the defendant's character was open the door and fair game, the court has never issued that ruling, and it's simply an absurd argument. What is different now is that they have decided to introduce evidence of the defendant's character, and pursuant to case law and the rules of evidence, I should be allowed to inquire about that, to rebut that claim that the defendant is making.
First of all, he's saying that he didn't introduce, you're playing something for the jury where his character is in question. Now, whether or not they specifically asked their witness, hey, do you know of any particular instances? The cat was out the bag. Once the video is played and they hear accusations about glasses from a pawn shop, they hear accusations about, oh, we looked your history up, we know what you've done before. Sergeant Ford was talking about his character. We know you. This is out of your character. He said those exact words. This is out of your character. You must have been working with somebody else. We know your history. That's character. If that's not character evidence, I don't know what is, because he used that phrase, we know your character. This has to be out of your character. I.e., we know you did it, but we looked in your history and you've done other stuff. We know about your history with cars. We know about your history with cars. But you don't have this particular history in your background as far as hurting people, so you must have done it under the direction of somebody else. They've opened the door. Now, whether or not they specifically asked Sergeant Ford questions about that, the jury's heard this. The jury's heard things about his background from them. So then we had to ask these questions. I had to ask these questions to clean it up, because the cat is already out the bag. You can't put the genie in the bottle once he's out. You can't unring a bell. And they rung that bell with their evidence, with their witnesses, multiple phone calls about him saying weird stuff, multiple things about him denying doing things to women, and Sergeant Ford specifically telling Mr. Jackson-Bolanos, I personally have researched your background, and I know your background, and I'm telling you your background, and I'm telling the world your background, because the world is watching right now. I'm telling the world I know about your background. And I'm also telling the world, I think you did this, but it has to be under the direction of somebody else, because this goes outside of your normal character. Now tell me that, that's character evidence.
But, Judge, the statements of Sergeant Ford are not evidence. Only the defendant's statements are evidence in that clip. Secondly, if they're claiming that the door is wide open to character evidence, then what are we even arguing about then? They should have no objection to me asking him about that if it's their argument that the door has been wide open. So what are we even arguing about?
They opened the door. So I can ask them questions. If they bring his character, I can ask them questions to clean it up. I didn't ask any additional questions. I didn't say, hey, are you the type of individual who would rob somebody? Are you the type of person who has ever hurt somebody? I didn't ask these questions. These questions were never elicited, even though the insinuation was already out there by Sergeant Ford. The insinuation was already out there, and the jury heard that. So they just want to put that out there and say, oh, we didn't open the door, even though we looked through this whole video recording, this whole interrogation. We took out the places where it's mention of a polygraph or mention of some other things, with no mention of character evidence. They didn't take that out. They didn't take things out like that. They took things about, question about things that we know are inadmissible in a court. So they took out a very small portion what they taken out. Same thing with their phone calls. They want to give the court the impression that they meticulously took out, the only things they took out was mention of character. If that's the case, it would have been only a 5-second muting of the jail calls, because that's how long that conversation was. They only played roughly 20 seconds of a phone call in order to mislead the jury, and then as a rule of completeness, we wanted to bring that in so the jury wouldn't think that we're hiding anything, because they're only cherry picking a small portion, just like the conversation that Mr. Jackson-Bolanos had with me, where he categorically denied doing weird stuff, i.e. going across the body and then taking things from the pocket. And then he wants to try to insinuate, he wants to take that out of context, that conversation out of context, mislead the court, and state that me as a counsel put these theories into Mr. Jackson-Bolanos' head. He tries to mislead the jury to try to insinuate that I told Mr. Jackson-Bolanos to say these things. Mr. Jackson-Bolanos already didn't say these things, or already didn't do this particular action, and I'm force-feeding him a theory. So then they take a very small portion out to mislead, where it has character evidence per them, where he's saying, I did not do any weird stuff. I don't do weird stuff like that. It's consistent. So I guess when they want to introduce some stuff to attack his character, we can't rehabilitate him. We have to be able to rehabilitate him. If they attack his character, we have the ability to rehabilitate his character. And did we do anything external or extra to do that? Absolutely not. It was a consistent statement which he consistently made during the entirety of his interview with Sergeant Ford and Sergeant Patrick Lang, where he categorically denied doing weird stuff, hurting people, going into houses, doing robberies, all of this stuff. And then Detective Sergeant Ford insinuated he knows his character. So we should be able to ask questions. And I asked him about his convictions, because obviously that's going to be brought up. He's testifying. So I asked him about his convictions. Has he ever been convicted of receiving control of stolen property? He stated that he was. But that's definitely going to be brought up in there. So yes. This was no, I didn't elicit how his character was. Are you a good person? Do you always treat women with utmost respect?
And Judge, if I may, the question that he posed to him was whether or not he was convicted of robbing or I think it was assaulting anyway.
Armed robbery.
Convicted.
I said armed robbery, not assault. I said armed robbery. Which is a crime involving theft or dishonesty.
And so the prosecutor has already mentioned to you that what he proposes to bring forth are not convictions. The question that was asked was specific to convictions. So therefore, Judge, I just don't think that should be allowed in.
Well, and Ford making reference to the character of what he was talking about was theft. That this is out of character for you,
right?
Because of the theft.
That's correct.
Which the theft is allowed to come in anyway, because
which is why we just brought it in.
Right, but he's still talking about his character though. He's still talking about, I know your character, and I've looked in your past, and this is out of the ordinary for you. He's open, the door is open about his character. He's mentioning his character. So even if he doesn't go into more detail, how much more do you need to say? If you mention, I know your character, and this is not like you. But I think you did it. This is unlike your character. I know about your other character traits was you're a thief. We know you're a thief. AKA we know you're a thief. That's a character trait that we know about.
And again, Judge, in all fairness, like this was the evidence was introduced by them, and they did redact portions of it, but they did clearly leave in very, very particular pieces of evidence, or I guess statements, I should say, within what they could have easily redacted. They left that in, played that for the jury.
It's evidence. It is evidence. Anything that comes from the screen or that chair is evidence. Whether or not it's believed or not, it's evidence, because the jury had an opportunity to hear it, and then they'll give whatever weight to it that they deem necessary, but it's still evidence that they introduced. And they introduced character evidence about Mr. Jackson-Bolanos, and then they want to say, oh, I didn't mean to do it, or we didn't intend to do it. You did it, though. Nevertheless, you did it. And we should have an opportunity to rehabilitate him, and all I did was ask about convictions. And then they want to say, oh, just simply because he said, I don't do weird stuff or I don't hurt women, consistently said that. That's nothing new that was being brought. So he want to say, oh, just simply because it was on a phone call that you guys introduced, nah, I just got free game, even though I introduced these same statements 10, 20 times during my exhibits, during my evidence, but the fact that he said the same thing that he said during this interview, then therefore I can just throw whatever. I can ask him about, his kindergarten girlfriend that he broke her heart or whatever the case is, and she was crying, for all night. So I can just introduce anything that's just unsubstantiated. I can ask him that. No, he's doing that because he knows that the prejudicial value outweighs the probative value. So he wants to muddy the waters and ask questions of, Mr. Have you ever done this? We got this police report that says this. We got somebody who accused you of, even though it was in charge, we got a police report of somebody accusing you of taking a phone years ago. Yeah, I know what he wants to introduce, but at the end of the day, whatever it is highly prejudicial.
Judge, he said that he had text messages at the podium. He's like, he wants to introduce text messages that were sent to Mr. Jackson-Bolanos. Judge, what are we doing at this point? It's a conviction or it's not a conviction. I think we need to kind of leave it at that.
Well, character evidence is different than conviction.
Sure.
But how does the door?
I guess I need to just see the text messages.
You want to read it or?
Sure.
And if you need a copy of that too.
Can we approach? Yeah.
know your character. I know your history. You had to be acting when you have with somebody else. I know you. I know you like you're my son. I got some. He said, I got some. He said, I got a son. He said, I got a son. He said, I got a son. So thank you for saying that. I know you. I know your history. I'm like, hey, this is out of your character. You know, I think you did it. But this is out of your character. So they introduce all of these things and Mr. Jackson-Bolanos is behind you. This is not me. I don't do this. It's repeated. I don't do this. So I thought it was good. I asked you, I didn't know if you did. I looked you up. But I said, hey, now, you are successful. So let's introduce it. So then they want to say that the fact that he said on the phone, oh, I have been on this stuff. And after there was a conversation, she said, no, about him being accused.
So concerned about other stuff as this thing.
He consistently said that. He consistently said there's him. He doesn't hurt him. He told the detective that. Period. I learned from him. This is nothing new that came out during this phone call. That should have come out during your hearing. Nothing new.
This is a statement submitted by you.
I mean, that's the rule of completeness. I'm not saying you're saying that always stated that that would be the purpose of this particular call. It's to listen. Just like they're saying that their character, everything, and it was not purpose. It was not purpose. So, just like they couldn't check it. When asked to play the whole call, they couldn't check it. They just told this character. You did a check. No, you did. You attempted to call the game. And the answer. And the answer. Back here at the sidebar. I don't understand why. You were up here. We had the courtroom. We specifically talked about admitting that whole jail call. Judge overruled us and how they put it in.
Your courtroom was referenced this. This was the courtroom.
So one of us was checked. No, we didn't check.
I don't remember your character.
Exactly, because it didn't happen. Because it didn't happen. Would you be honest? You asked him about it. I asked him about it. And we talked about it.
He said something from my
So, let's talk about it. That's not a character of untruth. He's not saying anything about his character. He's not saying, oh, I'm being true. He's not saying anything about character. A conviction is not character. They're two separate things. He didn't say he doesn't relish. He doesn't do that. They did during the interview with Sergeant Ford. I agree. You testified to say that. It's not a character. He didn't testify. I said he never convicted. He never said that.
There was a conviction. He asked about a conviction.
Never volunteered. Yeah, I mean,
messages, there's no reference there to any kind of violence, and that certainly is not, I'm not going to allow that to be admitted. However, when the jail call was played with conversation with the girlfriend, which was admitted by the defense in full, that portion was not played by the people. The defendant made specific reference to "I don't hurt women," and that is admitted by the defense at that point. and is introducing character evidence by the defense. Although it may have been stated by the defendant in his interview, the people would not have been able to ask about character reference based on anything in the interview that was admitted by the people. But when it's admitted by the defense, that opens the door to cross-examination about prior instances under Rule 504A. But the text message is not going to be allowed to be questioned about because there's no mention anywhere in there about any kind of violence. But you may ask about other instances that involve violence. That's my rule, and let's bring the jury back out.
Judge, they have all the discovery. To the extent there's any prior police reports or anything like that documenting any prior incidents, they have those.
But I think it should be, as far as what's going to be asked, it should be very narrowly tailored, and we should understand and know what those particular instances are.
They're coming in.
Hold on. Well, they said you should have copies of it.
But as far as what specifically they want to ask, it should be, they just give us an amount of the discovery, so it's somewhere buried in there, but you're saying that you should be able to.
Hold on. Do you have a copy that you can
I don't have them print out right now, Judge.
Can you email it to me and I'll print it out?
Sure.
The court should be able to take a look at that too to make sure it's permissible. And the court should review it.
Go ahead and have a seat. Brown. You may proceed.
All right, sir. I'm going to ask you some questions. If you don't understand any of my questions, just let me know and I'll ask the questions a different way, all right?
Good morning.
Did you understand that?
Yes, sir.
All right.
Good
So,
morning.
Good morning. How old are you?
29.
Were you 28 when all this happened?
Yes, when I was being accused, yes.
Yes,
I was
back in
28.
October you were 28, right?
Yes,
And back then, how tall were you?
the same height,
Okay, how tall is that?
5'11",
And how much did you weigh back then?
156.
So were you in like good physical shape back then?
I guess.
Didn't have any problems walking, running, jumping, that sort of thing?
No.
Okay. Now, back in October of last year, at least around October 20th, 21st, were you homeless back then?
No, I had places to go. I just didn't have a home of my own.
All right, so you would basically stay in a people that you knew's place for days or period of days, but you didn't have like a place where you were renting, right?
True.
All right, and so part of that time you're also living out of your car, right?
Correct.
Okay, and so when you would live in your car, would you keep your possessions in your car?
Yes.
All right, so your car, at least at the time where you were living in, and you're storing your stuff in there, that's kind of like your personal private space, right?
Yes.
All right, that's like your place of sanctuary, right? If you have nowhere else to go, you go to your car, right?
Sometimes.
Sometimes? I mean, if you weren't able to stay at a friend's house, that's where you would stay, your car, right?
No, I just go to my auntie's house.
Okay. Did you ever spend any nights sleeping in your car?
Yes.
And now you had a job at that time, you were a manager at a store,
Yes.
but you were also struggling for money at that time, right?
Not necessarily.
You didn't have enough money to buy your own place, right?
True.
Right. And you said to the police at least that you'd have to take showers at the gym, right?
Yeah, but that was for different reasons.
All right. Well, I mean, you didn't have a place of your own, right? So you needed money to help pay whatever bills you had to pay, right?
True.
Right. And so when you would stay with Tiara White, were you giving her money to help pay for rent?
Yes.
Right. So the money that you were making from your job, you were giving some of it away to Miss White, right?
And other places, yes.
Yeah, in other places. So the long and short of it is, you needed money, right?
Not in a desperate manner, but yes.
Okay. No, but yes. That's your answer?
Yes.
Okay. Now, just generally speaking, right, you've lied a lot when it comes to what you were doing over the course of October 21st in the early morning. Is that fair to say?
As in regards to what?
Just about what you were doing that night. You lied to the police a lot about that, right?
A lot about going into the cars at first because I have a history of cars and I did not want to be in trouble with the cars.
I'm not asking what you lied to the police about. I'm just saying, generally speaking, did you lie a lot in your interview with police?
A lot? No.
No? Okay. Do you remember that the police asked you why you lie so much? Do you remember that?
I don't.
All right. We're going to pull up People's Exhibit 107, which is your interview from November 30th. All right, now we're going to play a section of this video statement starting at 2 hours, 38 minutes, and 50 seconds.
Why you lie so much? Because I'm a defensive person. I don't lie. It's just that I get defensive. And bro, like, I know.
All right. So, you said, the question was asked, why do you lie so much? And you said, I'm a defensive person. I don't lie. Isn't that true?
Yes.
All right, but that itself was a lie, right?
No.
I mean, you do lie.
I was being defensive because they were accusing me of various of things, robbing jewelry stores, pawn shops, robbing people for glasses. This is what I was brought into the
I'm not
pawn shop
asking,
for.
my question for you is not why you were being defensive. The statement about I don't lie, that itself is a lie, right?
Yes.
Okay, so even in that statement you're lying, right?
No.
I mean, you just said, I'm a defensive person, I don't lie, but you do in fact lie, right?
It was the reason why I was lying.
I'm not interested in why you were lying, just the statement itself, I don't lie. That is a lie, correct?
Yes.
Okay. And within the first statement, after you were given your Miranda rights, remember telling the police that I don't steal?
Yes.
Right, that is a lie, correct?
Yes.
When the police asked you about these glasses, right, you said, I didn't steal the glasses. Do you remember saying that?
I said I didn't rob anybody or harm anybody for the glasses.
Right, but in fact, you did steal those glasses from that man, correct?
No. I did not steal glasses from an individual.
So do you remember telling the police that you saw the man at the mix and he was walking around saying, I lost my glasses, I lost my glasses? Remember telling the police that?
Right.
And then you said that you picked up the glasses and you took them to a pawn shop and stole them, right?
Stole them or sold them?
Sold them.
Sold them, yes.
All right, so you have a man there who's standing around looking for his expensive glasses, and you saw that happen, right?
Right.
And you decided to pick up the glasses and keep them, right?
Right.
Well, the man was standing right there.
He wasn't standing right there. He had already walked off by that time when I went to go retrieve the glasses.
All right, so you saw the man standing around looking for his glasses. You didn't say anything, right?
Right.
So then you pick up the glasses and you go and steal it. You go and sell them, right?
Right, I sold the glasses.
And then you kept the money.
I kept the money.
So you stole the glasses, right?
I took the glasses without permission, but I didn't steal them from a person. I didn't take it from him. They were on the ground outside.
I'm not asking whether you took it from his pocket or off of his face. I'm saying that you knew the glasses didn't belong to you, and you knew the man wanted the glasses, and you decided to keep them, right?
Right.
Ask an answer.
So you did that knowing that that property did not belong to you.
Right.
You also told the police that you don't hit cars anymore, but that was a lie, correct?
Correct.
You told the police that you didn't see anyone else out there, but your testimony here in court today is that that was a lie as well, correct?
They told me that I had went in somebody's house. That's what I told them. I did not see anybody. I didn't want to be accused of something I didn't do.
Right, so you told the police you didn't see anybody out there, right?
Right.
But that you're saying here today was a lie, right?
What?
Your statement to the police about not seeing anyone else out there, that is a lie, right?
Yes.
Okay. And then you also told the police that you never touched any bodies, right?
Right.
And that, according to you today, is a lie that you told to the police, right?
That was a lie.
So you are a liar, correct?
Okay.
And also, now talking about that night, I'm talking when you left the house on Alexandrine with Miss White, you testified earlier that she thought that you were going out for a walk, right?
Right.
But actually you weren't going out just for a walk, you were going to go and check out cars, right?
Right.
So that was a lie that you told your girlfriend, right?
Right.
So not only do you lie to the police, you also lied to your girlfriend, right?
Right.
And you would agree, though, that one of the reasons you lie is because you're defensive, right?
No, I think you're mixing them up. I lied to her because it was none of her business what I was going out to go do.
No, I'm not asking specifically about what you said to Miss White. I'm saying generally speaking, when you were asked why you lie so much, the first words out of your mouth were, I'm a defensive person. Do you remember that?
When being accused of something.
Right. When you're accused of something, you're defensive, and so you lie, right?
Right.
And so that motivation that you had to lie to the police, you would have the same motivation to lie here in court, wouldn't you?
Absolutely not.
Oh, are you not on defensive here?
No. I'm
No.
being honest here.
Okay. Now, when you left that night, you were out taking pictures of cars, right?
Yes.
And who are you taking pictures of cars for?
Just a group of Telegram group.
A Telegram group? Is Telegram like a messaging app?
Yes.
Who are the people that are part of this group?
I don't know. It's anonymous.
So an anonymous group of what, car thieves?
You could say.
Right, and so you're a member of this group of car thieves?
I wouldn't say a member.
Well, I mean, you're on the same group chat with everyone else, right?
Yes.
And you're actually helping these people to steal cars, right?
Yes.
By taking pictures of the cars, it's your understanding that somebody could possibly go and steal the cars that you're taking pictures of, right?
It's possible.
And you did that willingly, right? Nobody forced you to do that.
Right.
And what were you getting paid for your work in helping these other people steal cars?
I'm not sure if I was getting paid anything, meaning like I wasn't getting paid anything unless I took it myself.
So you're just sending out pictures of cars for people to steal, but you're not getting anything on the back end for your work?
Unless I do it myself.
All right, so you would want to document the cars that you're going to steal by sending them to a group text with a number of other car thieves?
Yes.
Right. And so are you proud of stealing cars that you just want to tell other people about it?
No.
So why would you tell other people about the cars that you intended on stealing on a group text?
Just a criminal hobby.
That's just something you do as a criminal? Is that what your answer
I only
is?
mess with cars, so it was something I do.
Okay. Now, as you're out walking around, you at some point make the decision that you're not just going to take pictures of cars, you're actually going to go into them, right?
Yes.
So, you are willing to go into the personal spaces of other people, right?
Cars, yes.
Right. So, just like you were living in your car and you had all your possessions in your car, you were willing to invade the personal spaces of anyone else by going into their cars, right?
Yes.
That's not a problem for you.
It is.
But you don't have any problem doing that sort of thing to other people. That's what I'm getting at, right?
No.
And when you're out there looking for stuff to take from cars, you're looking for any opportunities that may arise as you're walking around, right?
When I'm out there taking stuff from cars, I'm just looking for anything interesting.
Right. Anything of value?
Anything of value or the car itself.
So basically, as you're walking around, you see that a door is unlocked. You're going to go in because an opportunity has arisen for you to take something, right?
From a car, yes.
Right. And you said that, you know, whether it's a valuable item or a value that, or an item that doesn't have a lot of value, you're willing to steal both of those types of things, right?
Not necessarily everything has value to somebody or someone.
Mm-hmm. So you testified earlier that because of your habitual status, that you were worried that if you got caught breaking into a car, you would be facing a long period of time in prison, correct?
Correct.
So you're willing to risk all that over taking just any certain items that may be interesting out of cars.
Yes.
Now, when you went out there that night, you were wearing your North Face jacket,
Yes.
right? And this jacket is your jacket, right?
Yes.
How long had you had that jacket for?
More than 4 years.
All right. And so you also had your hoodie on your head, at the top of your head, right?
Yes.
And was your face also covered too?
Just this part.
The lower part of your face?
Yes.
I'm sorry, which,
This part.
so
The-
for
like the
the
nose.
record, the defendant is holding his hand over his mouth, indicating the lower half of his face.
And you testified on Wednesday that you didn't want your face to be seen, right?
Right.
Because you didn't want people to identify you committing a crime,
Messing with cars, yes.
right? Because you knew that the penalty for being caught committing a crime could be severe for you.
With the vehicles, yes.
Right. And so, because of that, you made an effort to hide your identity, right?
Yes.
And part of that also included putting on gloves on your hands, right?
When I found those gloves, I put them on.
Right, because part of the reason was if you were going to be touching on handles, you didn't want to leave fingerprints or DNA behind, right?
Right.
So that's also another step that you made to conceal your identity, right?
Right.
Now, when you talked to the police about the gloves, you said that they were winter gloves. You remember telling that to the police?
I do.
But that was a lie, right?
Right.
They weren't winter gloves. They were actually like rubber gloves, right?
Right.
Okay. And you've also testified that throughout the course of that night, you were trying to hide from people, right?
I was avoiding any confrontation or conflict, yes.
So not only are you taking steps to hide your face, your hands, you're also taking steps to get away from other people so that they can't pick you out, right?
No. Just was avoiding confrontation.
Right, because you were going out committing crimes and you didn't want other people confronting you about that, right?
Right.
Now, your phone number back then was 248-906-5529, correct?
Correct.
And you had your phone out the whole night?
Yes.
And that phone was functional?
Yes.
I'm going to refer to People's Exhibit 54. All right, so this is the report created by Agent Toltzis. Now, if we go to page 10 of your report, this report. All right, so you've been here for the testimony, correct?
Correct.
You've been able to listen to what everyone has had to say, right?
Correct.
Now, this page of the report, it basically shows your activity from 12:35 to 3:12 in the morning. Is that fair to say?
Correct.
Now, it shows, generally speaking, that you go from northwest to south towards downtown. Is that fair to say?
Correct.
And then from there, it goes east to the Harbortown area.
Correct.
Now, what we're seeing here, that's of the device that you were in possession of, correct?
Correct.
And that action of the device is actually how you traveled from Alexandrine over to Harbortown, correct?
Correct.
So the report is accurate, right?
I'm not familiar with these type of reports, but correct. I went to those places from Alexandria to Harbortown and back.
Okay. Now, if we go to the next page, page 11. Now, this says at 1:42 to 1:44 a.m. that the phone is hitting the area of Brevard near Joliet, where the crime scene is, correct?
Wrong.
It's not showing that?
No, it's showing Nicolette Place and Rivard. It doesn't even touch Juliet.
Well, I'm saying Joliet, that street is right in the same area where the band is, where the CCTV location is, correct?
Probably like a ways down.
A ways down, you're saying?
There, you're indicating to the red part where it says Juliet Place.
Right. How far do you think that is from where the CCTV location is?
Objection, Your Honor. He's asking him to speculate.
Yeah, I wouldn't know.
Well, he said it was a ways down. I'm trying to ask him what he means by that.
He's asking him to speculate. He's asking him to read this particular diagram, which is mischaracterizing, saying that this particular exhibit is encompassing the crime scene, which is not. And then he's trying to ask my client to basically speculate on how far he thinks the CCTV camera is from Joliet Place. And he can't answer that. It's speculation.
No. First of all, the location of the crime scene is indicated on the map. But secondly, he testified that the device was some ways away from Joliet. And so I'm just trying to inquire what he means by that.
When I was on Rivard, I was walking down Rivard where that yellow spot is.
Okay.
And Judge, I would renew my objection. He's asking him to, his original question was for him to speculate on how far he thinks that CCTV camera is from Joliet Place, and my client is not in a position to make some type of guess, especially if he doesn't know the specific location of the CCTV camera. It's not an address that's listed on here that depicts this is the area of he's not familiar with that. Well, he's not familiar with the distance.
Okay.
As far as the CCTV to the Joliet Place, as far as meters, half a mile, whatever that distance is, that's unfair.
Okay, can you ask him if the CCTV cam point is consistent with where he was?
All right.
That's a better.
The indication where the yellow or orange marker is at 1405 Rivard is that you were walking in that area, right?
Yes, I was walking by the yellow spot.
Right. So you were physically there before on that night, right?
Yes.
All right. And so that is close to Joliet Place, right?
I wouldn't know how close it is to Joliet Place.
Okay. So is the answer to my question, no, it's not close to Joliet?
No, it's not close to Joliet.
It's first a speculation, then he's asking relative. What is close? Close could be a matter of things to different people. Close could be, I live close to somebody in a different city, or feet, or whatever.
So, had you ever been in that Lafayette Park area where the parking lots were before you started walking down Rivard that night?
No.
You've never been there in your life?
No.
Okay. So, as you're walking south on Rivard, you hit Lafayette, and that's when you make a left turn, right?
Correct.
And it was around this time that you say that you noticed cars there?
Yes, there were cars on both sides of the street by the 1300 building, and there were cars on Lafayette.
All right, so when you're saying cars, you mean cars parked on Lafayette, not cars in the parking lot of Lafayette Park condo area.
Correct.
All right, so when you go down Lafayette, is that when you came into possession of this backpack?
Correct.
Now, on Wednesday, you said that you found the backpack. Do you remember saying that?
In a car, yes.
All right, so it was inside a car. You didn't find it on the ground.
No, I didn't say I found it on the ground. I said I found it in the car.
Right. So it was inside a car, and you went into the car and you removed the backpack from there.
Correct.
Now, that is stealing, is it not?
Correct.
You had no permission to take the backpack, did you?
Correct.
Did you take anything else besides the backpack?
From that car or other places?
From that car?
No.
Okay. So you get this backpack out of the car and you look inside, and you said that you found gloves?
I found corded headphones, a chapstick, I found some gloves, and a couple crumbled up receipts.
All right, so you found these gloves in there, and these just were the same gloves that you put on later, right?
Correct.
And so was it like a whole box of gloves like I'm holding here, or was it just like
a couple loose ones?
Like a couple of loose ones?
Yes.
And so this backpack that you found just so happened to have gloves that you would later use to help commit more crimes?
Yes.
And this area where you found the backpack, you've had a chance to watch the video of you walking around downtown, correct?
Correct.
This finding the backpack outside, that's not covered by any portion of the video, right?
I don't know, just not in the compilation.
Right. In the video that was played here in court of you going around downtown, you didn't see yourself going into the car to retrieve the backpack, right?
I did not.
So, you decide to take the backpack out. You take the gloves out, you put them on, right?
After checking through the bag, yes, I put the gloves on.
And so now you have something that you can carry around with you that you can help keep anything that you may find in other cars, right?
No, I didn't have it on. I stashed it.
Right, but I mean, like, the backpack, you could open and close it, right?
I could have, but I stashed it.
Just listen to my question. You had no problem using the backpack and retrieving items from the backpack, right?
Right.
And you could have just kept the backpack on and kept on walking around looking at cars, right?
I could have.
But instead, you decided to put the backpack down.
Correct.
And you did that even though the backpack would have been helpful to store any stolen property you might later find, right?
Could have been helpful.
Well, I mean, the gloves were helpful, right?
In a sense, yes.
But the backpack would have made your life a lot easier. Instead of toting around a white bag, you could have simply put any items inside the backpack.
Well, I found the bag later on, the white bag.
I understand that, but my question to you is, the backpack would have been helpful for you to put stolen items in.
It could have
You
been.
haven't asked and answered. Already said.
So stay. Move on.
So, around this area where you took the backpack, how long would you say you were in that area around Rivard and Lafayette for?
I'm not sure the exact time.
Would you be surprised to know that your phone is in the area for at least 20 minutes around 1:42 in the morning?
I wouldn't. It was a lot of cars on the street.
All right. So you may have been lingering around over there for 20 minutes, right?
With cars on Lafayette Street, yes.
Okay. So, was that the first car that you broke into that night?
No, it was several before it on the street.
All right. So even before you got to Rivard and Lafayette, you had already stolen items out of cars.
No, when I got to Lafayette is when I started.
Okay. So just in that area, there were a number of cars that you stole from?
Yes, on the street.
What else did you steal?
Nothing. It had nothing in it.
All right. So how many cars did you go into?
4 or 5.
So you went in 4 or 5 cars and you didn't find anything of value other than this backpack?
Nothing of value.
Okay. Nothing. You didn't remove anything out of the cars besides the backpack?
Correct.
So after you do that, you keep on walking in the easterly direction, and is that when you get to the area where you come into possession of this white bag, correct?
No, the white bag was off of like Jefferson.
Was it at White McDougal?
Yes, but I was at Ducharme Place before that.
All right. Well, at around 2:57 in the morning, you were in the area of White McDougal, right?
Right.
And that's when you came into possession of this white bag, correct?
Correct.
And you stole that bag out of a car, right?
Correct.
You didn't have any permission to take any of that stuff out of the car, right?
I did not.
And you're saying that inside the bag was candy, right?
That's correct.
Nothing else besides candy.
There was nothing else in the car.
So you decided that, this candy is an opportunity you just can't pass up. You're going to have to take the candy with you.
I just decided to take the candy and eat the candy.
Right, but I mean, there were other points where you testified that you saw people coming around that area at White McDougal, right? Do you remember
Correct.
saying that? And so when you saw people coming, you ran away, right?
I walked away.
Walked away, ran away, but you got out of there, right?
Correct.
Because you didn't want those people to have any sort of contact with you.
Correct. I didn't know if it was their car or anything.
Right. So you didn't want to be identified by them, right?
I didn't want to be caught going into somebody's car.
Does that include being identified as somebody breaking into a car?
Could be.
Right. And so you don't want any conflict. You don't want to be identified, so you walked away from where those people were.
Correct.
And after the people left, then you went back there to try and go get the white bag, right?
Correct.
So even after you nearly got caught stealing, you decided, I just got to go back and get that bag of candy.
Because I had dropped it outside the car, so I went back for it.
Right.
After the coast was clear, yes.
But knowing what the stakes are for you, how important this is that you don't get caught committing a crime, you just decided, I have to return and get that candy.
When the coast was clear, I did, yes.
Now, you lied to police about where the bag of candy came from initially, right?
No.
You didn't tell police that you got the candy from a store, that it was a store bag?
I did go to a store and I went to a BP gas station and they claim they don't have the video of that, but I did go to a store.
All right, so when police were asking about the white bag in your hand and you said it was a store bag?
Yeah, I told them that it was a store bag.
Right, but they were talking about the bag that you stole from the car.
Correct.
So you lied to the police when you said it was a store bag.
Correct.
And then later on, you go and you hop over the wall of a parking structure, correct?
Correct.
Now, that parking structure, you had no permission to be in there.
Correct.
So again, this is another example of you going into private spaces that don't belong to you. Fair to say?
For the purpose of cars, yes.